Right, good morning, everyone. We're going to go ahead and get started. Before I do, though, I'm going to give you a few housekeeping tips with regards to those logging in through Zoom. Currently, right now, I have our IT rep, Troy, taking care of everybody being put on mute. If you do have a question, you have two options. You can raise your hand and Troy can unmute you and you can ask the question, or there is a chat icon that you can select and type in a question and I will answer that as we receive them. Another thing to be mindful of too, part of this training is about interacting, so I will be calling on people, so be mindful that if I see your name here, I might call on you regarding a question that we might have, or call in the group in Las Vegas or the group in Elko. Okay. I'm going to go ahead and get started. For those of you with Zoom, I have given you the option of downloading the PowerPoint as well as the attachments, additional handouts, so you can follow along. So today's topic is on advanced care planning and end-of-life considerations. We are in partnership with Project ECHO to make this possible via interactive video and Zoom conferencing. It's also supported by the Nevada Aging and Disability Services Division. My name is Dolores Ward-Cox. I'm the Education Coordinator for the Nevada Geriatric Education Center. I'm also a certified gerontologist too. So just a little background history for those of you who don't know me. I obtained my Bachelor's of Science as well as my Master's of Science at UNR in Human Development and Family Studies, with an emphasis in gerontology, so in aging. I taught at the university for 3 years in courses on gerontology, and then worked at the Alzheimer's Association for 5 years as a program director, and now I've been with NGEC for the past 2 years. So advanced care planning and end-of-life considerations. Today's learning objectives are to understand what these documents mean and signify, identify strategies for successful communication regarding end-of-life considerations, demonstrate best practices for end-of-life care, and discuss resources for bereavement care. So what is an advance directive? What is a power of attorney? What is a living will? And why is planning ahead so important? So before I get started, and before you look ahead in your handout, I'm going to ask the individuals here, the participants here in Reno, what their understanding is of an advance directive. Can anyone share with us what their understanding of that is, or their definition of that is?
Outlines your care choices for what you would want to happen if you were not able to voice them on your own.
Great, so it outlines your medical decision when you are unable to make that choice for yourself. So think of advanced directives as the umbrella term. Underneath that are different types of forms that make up that advanced directive. So advanced directives are legal documents that allow you to plan and make your own end-of-life wishes known in the event that you are unable to communicate. Advanced directives consist of a living will, a medical or healthcare power of attorney. There's also the DNR orders or DNI order. There's also a donor registry enrollment form, and we'll go over that more throughout the presentation or throughout the training today. So a living will describes your wishes regarding your medical care, and with a medical power of attorney, you can appoint a person to make healthcare decisions for you in case you are unable to speak for yourself. So we're going to go over that in more detail. So power of attorney. The first handout that you have in the back of your PowerPoint is the durable power of attorney for healthcare decisions. I included this document so you can have a better idea of what a durable power of attorney form looks like. Nope, it's the Nevada one. Yes. So this is what it looks like. So if you just take a few moments just to read it over, for those of you who already know of it, sorry for the redundancy, but for those of you who don't know, this is what a durable power of attorney for healthcare decisions form looks like. It kind of gives you instructions and directions in the front of the page, and then the rest of it kind of goes over what you need to do, who you appoint as your healthcare agent, so on and so forth. So we'll go over that in more detail too within the PowerPoint. So a medical power of attorney is an advance directive that allows you to select a person you trust to make decisions about your medical care if you are temporarily or permanently unable to communicate and make decisions for yourself. This includes not only decisions at the end of your life, but also in other medical situations. In Nevada, this document is called a durable power of attorney for healthcare. This document goes into effect when your physician declares that you are unable to make your own medical decisions. So in Nevada, the person you choose or select to make those decisions for you is called your healthcare agent. In other states, they may be called a surrogate, attorney in fact, or healthcare proxy. But just so that you're aware, it's healthcare agent here in Nevada. So who should you select to be your medical power of attorney, that healthcare agent? You should select someone you trust, such as a family member or a good friend, who understands your wishes and feels comfortable making healthcare decisions for you. You should have ongoing conversations with this person to talk about your wishes at the end of life. Make sure your conversations with this person, or make sure your medical power of attorney feels comfortable and confident about the type of medical care you want to receive. Most state laws prevent your doctor or any other professional caregiver from being assigned as your healthcare agent, so being mindful of that. You can also select a second agent as an alternate in case your first healthcare agent is unwilling or unable to serve. So in a lot of the forms that you see, you will have the option of who is your healthcare agent, who would be the second person, and then even in some other forms, who would be the third person if those two are unable to make that decision for you. Are there any questions so far with regards to a durable power of attorney for medical? Okay, and just so that you're aware, there are two types of power of attorneys. There's a power of attorney financial, and there's a power of attorney medical. So what we're talking about today is the medical aspect of it. And just like what the financial states, that person, that agent, is in charge of your financial situations, whatever that might be. But being aware of that, some people who think they have the durable power of attorney medically think they also have that power financially, and that's not the case. There are two separate forms you need to fill out for that.
Is there a question?
Yeah, Dolores, we have a question in Las Vegas.
Okay.
Hi, I was informed there was a new power of attorney for healthcare called a statutory power of attorney. What's the difference?
That is a good question. Where did you hear that information?
Well, after I heard it, I downloaded one copy of it, but I really don't know what the difference is between the two. I just know that I went to a seminar with an attorney and they said that the new form of healthcare document is now called a statutory healthcare document.
Okay, I don't know if maybe they just changed the name to reflect that. That's a really good question. I will look into that and send it to the whole group in Las Vegas since I have your information. But I will look into it.
Thank you very much.
You're welcome. Very good question. Okay, so a living will. A living will is an advance directive that guides your family and healthcare team through the medical treatment you wish to receive if you are unable to communicate your wishes. According to the state of Nevada's living will law, this document is considered legal as soon as you sign it and it is witnessed. There's a witness signature involved. A living will goes into effect when you are no longer able to make those decisions. So typically, a living will, people refer to this as the patient's wishes. So there's a form that states just the patient's wishes versus a durable power of attorney, which states the healthcare agent. So those are the differences between the two. Oftentimes, people will have one or the other, or they have both. So just as long as they have one, it's great. If they have a living will, all they need to be aware of is if they don't have somebody who's authorized to make that medical decision for them when they're no longer able to, the medical team will then make that judgment or that decision for them. Also with that, actually, I stand corrected because I looked at the Nevada statutes. When it comes to making that medical decision for you, we had this conversation on Tuesday. The Nevada revised statute prioritizes the order of authorization in the event that there isn't an advance directive. So I think with the living will, though, if you do have a living will and you don't have anyone assigned, what will happen is it will first go to the spouse. The spouse will make that decision for them. And if they don't have a spouse, or the spouse is deemed not competent to make that decision for them, it will go to the adult child. Now, if there are more than one adult children, it would be the majority vote. And if it is, in fact, a stepchild, if they were not legally adopted, they would not have a say in that majority vote. It would only be those who have that legal say. So an adult child who was born through blood, or if they were legally adopted, would have that. Now, if there are no children, it will go then to their parent, the patient's parent. And if the parents are deceased, it would go to the adult sibling, so brother or sister. And if there are more than that, again, it's the majority rule. So that statute is, if anyone's interested, it's 449.626, if you wanted to look more into that. Are there any questions so far? And again, just either raise your hand or you can put it in the chat box too, if questions arise. So when thinking of your wishes, you want to think about your values when you're filling out these forms. Would you want treatment to extend life in any situation? Would you want treatment only if a cure is possible? And have discussions about your personal wishes. So we're going to give you I'm going to give you some references and resources on how to have these conversations and how to start thinking about this when it comes to making those end-of-life decisions. So when thinking about your advance directives, please be mindful that this is not when you are at the end of life. Anyone over the age of 18 can fill out an advance directive. You just want to be mindful that something that you fill out when you're 18 can be drastically changed when you're in your 30s, 40s, 50s, and so forth. So updating that is something you want to think about too when you're filling out these forms. Because you cannot expect what the unexpected is to happen. You know, you can walk outside, drive your car, and get into an accident, and something happens where you are no longer able to make that decision. You then have an advance directive that your medical team knows of, or your healthcare agent is aware of what the steps that need to be taken that adhere to your wishes. So what do I need to know about end-of-life decisions to prepare my advance directive? You want to learn about life-sustaining treatments, and you can do this by speaking to your physician. Life-sustaining treatments are specific medical procedures that support the body and keep a person alive when the body is not able to function on its own. Making the decision about whether or not to have life-sustaining treatments can be a difficult decision depending on your situation. You might want to accept life-sustaining treatments if they will help to restore normal functions and improve your condition. However, if you are faced with a serious life-limiting condition, you may not want to prolong your life with life-sustaining treatment. The most common end-of-life medical decisions that you, family members, or an appointed healthcare agent must make involve the following. So resuscitation, mechanical ventilation, tube feeding, dialysis, antibiotics, comfort care, organ donations, and donating your body. So these are all detailed in your living will or durable power of attorney form, and it goes over scenarios that might occur and what you would like to do with regards to life-sustaining treatments. So if there's any question that you have regarding what these treatments entail, I suggest that you speak to your physician about that. Because it may be somebody who's on dialysis, and maybe, you know, they're so fearful of dialysis, but, you know, does it really hurt the body? Well, initially with the needle and with the injection, it does hurt initially, but then it's, you know, manageable afterwards. So just being aware of what these procedures all entail will help you make those decisions as well. Any questions so far? Okay. So how can I prepare my advance directive? So you can fill out a living will and medical power of attorney form without an attorney. So that's on this part of it. It is important that you use advance directive forms specifically created for your state. So if you just go onto the state website, it does pull up the forms that you can use. There are other forms that I'll be talking about too that are more user-friendly that can help you throughout the process, or help you share with your clients so it's in layman's terms for them to understand. Read the forms carefully and make sure you follow legal requirements determined by your state. What you want to do is keep your completed advance directive in an easily accessible place, and give photocopies to your primary medical power of attorney, so your healthcare agent, your secondary or alternate agent, and your doctor or medical team. Another thing to keep in mind too is a lot of senior centers, even in the rural areas, they do have the option of attorneys coming in once a month and providing free services. So maybe having your clients, or if you're concerned, referring them to the local senior centers and asking, you know, is there an agenda where an attorney is going to be presenting because I have questions regarding my advance directives, or who can I contact? So a lot of senior centers have a lot of options for you as well. So you want to keep a record of who has your advance directive. On the forms, on those advance directive forms, it does give you the option of keeping track of who you gave it to. And the reason why this is important is if by chance you decide to change your advance directive, you then know and have a record of who you gave the old ones to, so they can update it and shred that old copy. You want to talk to family members regarding your decision so everybody's on the same page, so there's no conflict, and they understand that these are in fact your wishes and what you want to have happen. You want to carry a wallet-sized card if possible. I will show you in one of our examples with the 5 wishes sample. It does give you at the end of the page what that might look like and what you can create yourself. And you want to keep a copy with you while you're traveling. Now, we do here at the state of Nevada have what's called a living will lockbox. So that would keep all your advance directives in the cloud, quote unquote. So if you are traveling or if you're going somewhere, in your wallet-sized card, it will state you can obtain my information at the Nevada Living Will lockbox at this website, and this is how you can access it. And it is a free service on our state website. So just so that I'm going back here to what makes the advance directive legal and binding is if it's signed and witnessed. That's more of a self-authenticating process. I would highly suggest that you have it notarized versus that. But if you don't have the option of getting it notarized, just as long as it's signed and witnessed, it's deemed a legal document. And if at any time throughout this process or years later, you find out that the person that you designated as your healthcare agent is someone you do not want, you can revoke that at any time. And most of the forms, all you do is put revoke on that healthcare agent's name, and then you will write the new healthcare agent's name that you want to represent you. So it doesn't mean when you designate somebody to be your healthcare agent, that is the person in fact that you have to use. No, you can revoke that or change that at any time.
Dolores, we have a question in Las Vegas.
Yes?
When we revoke the designated power of attorney and we want to change it to someone else, does that need to be done in front of a notary or witnesses are sufficient?
Witnesses are sufficient as long as it's signed and dated, again, with a witness. That's a self-authenticating form and that's legal and binding. I just personally like it notarized just so that there aren't any questions with regards if it goes to trial, if the witness cannot be found, at least with the notary, and it being notarized, it's more authenticating. Does that
Thank
answer?
you.
You're welcome.
Is
We
there
have
any-
one more question.
Oh, yes.
Hi. Could you maybe explain the difference of filling out one in the community versus when you're in a long-term care facility and what's required when you're incapacitated in a facility and you want to complete a power of attorney? What is required in that circumstance as opposed to if you're at home?
Okay, so, I mean, that's why we're having this discussion. It's always good because most times, you know, this conversation arises when it's a crisis situation and you have to fill out those forms. So what has to happen is if the person is deemed incompetent and unable to make that decision, they cannot fill out the form themselves. It would then have to go through the spouse and what I had just mentioned, who would then have that legal right to make the decision for them. So say, for example, they are incompetent, the physician has says they cannot make this decision for them, they then go to the spouse and the spouse can fill out that form and represent them. Does that answer your question?
Yes, thank you.
You're welcome. So,
Any other questions?
any other questions?
Is there a question from E. Scott? Yeah, go ahead and type it in. We can see it. Can you see that?
Yeah, I can. So can you distinguish between incompetence and incapacitated? So the question that we have in the chat box is, can you distinguish between incompetence and incapacitated? So incompetent, meaning they cannot verbally share or state. So the physician will go in and do a competency evaluation. So that's a really good question. When you're incapacitated, they will see, it all depends on their competency evaluation. So if they're incapacitated but competent to make the decision, the physician will make that decision for them, that even though they're incapacitated, they're still able and verbal to make the decision, versus somebody who's incompetent, they don't have the say or verbal or can verbally state what they need to say. I will explain that more in depth and detail. I know that's very confusing. So I have your email, so I will email you that answer. I will email the whole group regarding the difference between incompetence and incapacitated, so it's easier to understand.
I have another question here.
So and another question is, are witness required for an initial advance directive or only for a change of healthcare agents? It's for both. Any sort of change that you have, or any sort of advance directive that you fill out, it needs to be signed and witnessed and dated. And the reason why that's so important is whatever is the most recent dated document that you have, that is what the medical team will follow and adhere to. The most recent document is the most valid. So in order for it to be legal, it has to be signed, witnessed, a witness signature, and then dated. Is that it, Troy?
I think so. I was just
Okay. Very good questions. Okay, so who would decide about medical care if I do not complete an advance directive? Oh, well, we already mentioned that. So reviewing and changing advance directives. It can be changed at any time. I already mentioned that earlier. You can create a new form to reflect those changes. You want to distribute new copies to those that you have already distributed to them before, so keeping track of who you've given it to. But again, as long as they have whoever has the most recent one that's dated, the most recent date, that is the advance directive that the person or the medical personnel will follow. You want to destroy all old copies, and the most recent signed form will be valid. So when should you consider reviewing and creating a new advance directive? This could be a new diagnosis that you have, a change in marital status. So say maybe you want that person to be your healthcare agent instead. Perhaps a change in your wishes. Another thing too, and we mentioned this earlier, advanced age. So you might want to do it because things may change as you age and your wishes might change as well. So you want your advance directive to reflect that change. So we're going to go on to some resources that are out there. One of which is our 5 wishes. So that is in your handout as well. So it's the sample 5 wishes document. So the 5 wishes document is an advance directive. It meets the legal requirements for an advance directive in the state of Nevada. And just like most other states, you can use 5 wishes in Nevada to express how you want to be treated if you are seriously ill and unable to speak for yourself, and using a document that is easy to understand. So this is really important for you to kind of look over. This is the form that a lot of states have been using, only because it's more user-friendly. So you can go onto their website at 5 Wishes. So it's in your PowerPoint. So it's agingwithdignity.org /5-wishes. So you can obtain that form online. You can request for them to mail it to you, or there's a editable or fillable document online that you can fill this out as well if you're more computer savvy.
Is it state specific? State by state?
No, it's not. I mean, it's not state specific. So this form is the same form as what you would download in, Alaska, Colorado, Florida. So, but it is viewed here in the state of Nevada. It meets the legal requirements for the state of Nevada as an advance directive. So at the end of this page, so here the wish 1, just so that you can see, it states the person I want to make healthcare decisions for me when I cannot make them for myself. So it has you fill out who you want to choose as your healthcare agent. And then it has your second choice and third choice name there. So as you read through it, it's very easy to understand when filling it out. But if you have questions, I highly recommend that you speak to your physician regarding it, or an attorney if you have an attorney, or using the senior center, that free service too. So at the end of this, on page 11, it does show you an example of what the wallet card might look like. So you can cut this out, laminate it, and just keep it in your wallet for safekeeping. So it shows you where your document is located, your living will, or your advance directive, who your primary care physician is, and then who your healthcare agent is. Are there any questions regarding the 5 wishes?
We have one in Las Vegas.
Okay.
In Nevada, here in Las Vegas, there's the health district that has a card similar, so that the paramedics, if you're out in the community and you get in an accident, they can look it up and you're registered as being with the Clark County Health District and not wanting CPR. So that's the only card that they will honor. But will they honor this one? That's what my question is.
So with that, we'll be talking about those DNR orders as well to clarify more. So what this card just states is that they can obtain the information that you need with regards to your advance directive, like your wishes. So when it comes to DNR or DNI orders, I will discuss that in more detail because there's a difference. This just states who's the healthcare agent, who's there, and they can look at that. And if a person is saying, for example, they don't want CPR and that's stated in their DNR order, but they can't find a DNR order, they will then see here that the healthcare agent is in fact that person and they're stating that. So this is just an informational sort of card for them to obtain information when they need it, you know, en route to the hospital. But I'll discuss more with the DNR and DNI order here shortly.
Okay.
Okay. So 5 Wishes, here's the website for you all. And hopefully that's legible in your PowerPoint that you can obtain. Okay, perfect. So the conversation project. So this PowerPoint was in partnership with the Cleveland Clinic, as well as with a local attorney here who went over this PowerPoint with me. So these are resources that she found were helpful, and so does Cleveland Clinic. So we're just going to go over those resources. So the conversation project goes over, so it's dedicated to helping people talk about their wishes of end-of-life care. Too many people are dying in a way they wouldn't choose, and too many of their loved ones are left feeling bereaved, guilty, and uncertain. So what this website helps you with is having that conversation with your loved ones, whoever you designate as your healthcare agent. So they have what's called a conversation starter kit, and that is also included in your packet. So what this website or what this organization is trying to do is transform our culture. So we shift from not talking about dying to talking about, not talking about dying, but talking about it. So we always have this phobia or taboo when it comes to death and dying. But this starter kit will help initiate that conversation. What would I want to have happen? So a lot of people have difficulty starting these types of conversations. It's all relative, so every family is different. So within my own family, it's just as simple as asking the question. When I was getting this PowerPoint ready, I had the conversation with my parents. My dad was helping me with the PowerPoint. He's a judge, so some legal questions that I had arise, he was helping clarify that for me. And I said, you know what, Dad, this is very interesting. So have you and Mom filled out your advance directive yet? Do you have anywhere that states what your wishes are so, your adult children don't have that disagreement? And he said, no, not yet. They're working on it. So I've asked him ever since then, every week, how's it going? Here's the form. How can I help you with this? Why don't we, designate a day where we can sit down and have this chat, And of course, our parents look at us with adult children like, you kids have no clue. So there's different barriers and things that you have to be mindful of. But even if you're a professional out in the community, cultural barriers are huge. Even within my cultural background, my aunt just came to visit us for the holidays, and we're talking about her estate. And as she's talking to me, I'm like, okay, Auntie, well, where can we find this? Where have you noted this, or where's the document that states what all your estate entails and who will be your trustee and so on and so forth? And she told me, well, I don't have anyone. And I said, okay, I'm confused. You've stated everything that you have, and this is who it goes to, and your family will make this decision, but it needs to be written down in a legal document. And she says, it doesn't need to be legal. I have verbally said what I've said, and that should be that. So just having those conversations, some people think that when they say it verbally, that it's set in stone, but it's not. And if that's the case or situation, as she's stating these things to me, I then presented it to my dad and brother. My brother's an attorney as well. And they said, well, Dolores, since you know so much about our aunt, maybe what you need to do is write it down for her. Because maybe people have that barrier too, where they're able to verbally tell you what they want, but they cannot put it in writing. So we've started the process where I'm writing down what she needs or what I understood she wants, and then we can move forward with the process. So that might be in this situation as well. Say somebody, can verbally tell you what they want, but they're kind of fearful of filling out the form. Maybe you fill it out for them and then review it with them and say, this is what I understood that you said. Is this correct? Does this make sense? So just having those options. But this conversation starter kit is really a neat tool for you to have when initiating those conversations. Or if you're directing a family member, if you're a professional in the community, just handing this packet to them would be resourceful. Okay, so another reference or resource is the American Bar Association. You also have a handout here, and this could be helpful too when you give it to your clients or your patients that you're working with. So American Bar Association Free Legal Answers is an online version of the walk-in clinic model where clients request brief advice and counsel about a specific civil legal issue from a volunteer lawyer. So there are qualifications to meet this resource, and it's stated here on the flyer that it services to low-income populations. So what it does is lawyers provide information and basic legal advice without any expectation of long-term representation. The purpose of the website is to increase access to advice and information about non-criminal legal matters, so whether it's advanced directives or your estate, to those who can't afford it. So there is no fee for the use of the system or for the advice and information provided by the attorney. So that is what that handout is for you to reference. Okay, are there any questions so far? Okay. So for the Center of Practical Ethics, this is also another resource. Similar to the Conversation Project, it has those caring conversations form. Now this was a lot of paper, so I didn't print this out for you, but if you go onto their website and just type in caring conversations, this form, this guide will pop up, and it's to help family and friends through the process of advanced care planning. So going over it step by step, and this also is a fillable document. So you can access it online and just fill it out online as you're discussing that with your client or with a loved one. So just wanted to give you those resources. All right, so we're moving on with end-of-life considerations. So when it comes to end-of-life, we talk about hospice care, hospice services. So what is your understanding of hospice? Let's do it here in Reno. Can anybody tell me their understanding of what hospice care is or what that entails? Pretty sure everybody knows, but comfort care, palliative care.
To end of life within the last 6 months as designated by a doctor.
Yep, so it's hospice services are given, or hospice care is given if you have 6 months or less to live, designated by a physician. But there are different types of services that are provided within the hospice care. So hospice care is considered to be the model for quality, compassionate care for people facing a life-limiting illness or injury. So hospice care involves a team-oriented approach to expert medical care, pain management, and emotional and spiritual support expressly tailored to the patient's needs and wishes. So a lot of hospice services too, support is provided to the patient's loved ones, and there's coaching involved too. I think that's mentioned here. Here it is, in coaching families. So hospice focuses on caring, not curing. And in most cases, care is provided in the patient's home. So hospice services are available to patients of any age. And it is covered under Medicare. You can mention that somewhere in earlier here. Oh.
Who was in the first one?
In the first one.
Oh, there it was.
Okay, sorry. So it is covered under Medicare, Medicaid, and most private insurance plans and HMOs. So what the hospice team develops a care plan that meets each patient's individual needs for pain management and symptom control. So the team usually consists of the patient's personal physician, hospice physician, nurses, social workers, clergy, trained volunteers, and speech, physical, and occupational therapists if needed.
Excuse me,
Yes.
they're including the primary care in the team?
The primary care is, you have to discuss it with the primary care first with regards to hospice, because it's the primary care physician who refers to hospice. And then afterwards, it becomes the hospice physician that takes that responsibility.
6 months or less to live? Has that changed at all?
No, it's usually if they have 6 months or less other hospice services are different. It depends on the hospice, but typically the baseline of that is 6 months or less to live. But you can be on hospice more than the 6 months that
Years.
yeah. So depending on Medicare, Medicare is constantly changing when it comes to hospice services. So you want to talk to the hospice team to gain a better understanding of what that all entails. Does that make sense for everyone?
We have a comment in Las Vegas.
Yes.
Hi, I've been a hospice social worker for many years here, and one of the things to soften the blow of 6 months or less is to say that at the time that the doctor is seeing you, at that moment in time, he has to believe that you have 6 months or less to live. However, that could change once you're out of the hospital and you could live an extended period of time. The qualification to remain on hospice is showing consistent decline in the condition that you came on hospice for. So that way they understand that they can improve, and as long as they're improving, we are monitoring for decline. If decline is in evidence, you can be signed off of hospice at some point.
Perfect. Thank you so much. I appreciate that.
You're welcome.
Okay. So bereavement resources or bereavement care. This is also a handout that's provided to you as well. So it's through the Care Dimensions website, and you can obtain that information on your handout. It says how to log in, so it's www.caredimensions.org. So bereavement care is an essential component of hospice care that includes anticipating grief reactions and providing ongoing support for the bereaved over a period of typically 13 months. Each hospice service is different, so some are 13 months, some are 6 months after the person has passed. So again, having that conversation with the hospice team to understand what those terms are. So bereavement refers to the state of loss, and grief is a reaction to the loss. So this handout goes over the stages of grief. Right, so when you grieve, it's part of a normal process of reacting to loss. You may experience grief as a mental, physical, social, or emotional reaction. Mental reactions can include anger, guilt, anxiety, sadness, and despair. Physical reactions can include sleeping problems, changes in appetite, physical problems, or illness. As I was doing this training in a rural site, one person had commented that she was the primary caregiver for her aunt, and she was a primary caregiver and lived with her for 5 years. And after her aunt passed, it was almost like a relief for her. And she really didn't deal well with people coming over all the time, giving her meals, checking up on her. You know, her initial reaction was, I'm fine, I'm doing great. I'm not grieving. I don't need this sort of help. And as she's sharing this with me, it was very opposite of what we typically hear of is, typically when a person has passed, usually those first couple of months, that person is inundated with so much family and friends and neighbors taking care of them. It's only after that 2-month period has passed that you start to see them grieve and going through the grieving process. So just being mindful that sometimes it takes a while for people to start that grieving process, and helping them be aware that there are resources out there to help them with that. There's also support groups that are out there that they can join and you can refer them to. So maybe looking that up at wherever you are locally to giving them the best resources that's out there. Are there any questions regarding bereavement care? Another thing I want to mention too when it comes to resources, here in Northern Nevada, we have what's called the Golden Pages. And I should put that up online, our Golden Pages. In Southern Nevada, you have what's called the Royal Pages. And that's, I refer to the Golden Pages as my Bible because it states all the resources that I could possibly think of or need in Northern Nevada. So it has hospice, it has pharmacies, homemakers, companion programs. So you can access the Golden Pages online for those of you who are in Northern Nevada. They print this off once a year, so they're in the process of updating it, I believe, in March. So this is our version here in Northern Nevada. And then in Southern Nevada, if you just go onto the website, it's called, on Google, you just type in Royal Pages, and this is what will come up. So it's just a directory of programs and services in your area. So it's a helpful resource for you to have, to put it as your favorites or mark it as your favorite on your website or on your webpage. Any questions there? Okay. So next we're going to talk about, I know we had some questions regarding do not resuscitate, so a DNI order, and a do not intubate order. So just so that people understand, I'm pretty sure you already know, what is cardiopulmonary resuscitation? So what is CPR? So I'm just going to define that for you so you understand. So CPR is a group of procedures used when your heart stops, so cardiac arrest, or breathing stops, so respiratory arrest. For cardiac arrest, the treatment may include chest compressions, electrical stimulation, or use of a medication to support or restore the heart's ability to function. For respiratory arrest treatment may include insertion of a tube through your mouth or nose into the trachea, so your windpipe, that connects the throat to the lungs, to artificially support or restore your breathing function. The tube placed in your body is connected to a mechanical ventilator. So just wanted to give you that definition so when we discuss the DNR and DNI order, you understand it a little bit better. So a do not resuscitate DNR order is a written physician's order that prevents the healthcare team from initiating CPR. The physician writes and signs a DNR at your request or at the request of your family or appointed healthcare agent. If you do not want to receive CPR in the event of a cardiac or respiratory arrest, the DNR order must be signed by a doctor, otherwise it cannot be honored. So DNR orders can be canceled at any time by letting the doctor who signed the DNR know you have changed your decision. It can remain in effect if you transfer from one healthcare facility to another. However, consult the arrival facility's policy to make sure of that. And then it may not be honored during surgery, but this is something very important to discuss with your surgeon and anesthesiologist before surgery, so your wishes are honored and should be posted in the home if that is where you're being cared for. I know here in Nevada, it's usually on a salmon colored paper, sometimes on a yellow colored paper. So somewhere where it's easy for EMS personnel to see it as they come in. It could be on a bracelet too for them. So just being mindful of that. So if there is no DNR order, just to clarify, the healthcare team will respond to the emergency and perform CPR. The team will not have time to consult a living will, the family, the patient's healthcare agent at the patient, or the patient's doctors if that is not present, if a DNR order is not present. So when it comes to a do not intubate order, when you request a DNR order, your physician may ask if you also wish to have a DNI order. Intubation is the placement of a tube into the nose or mouth in order to have it enter your windpipes, that trachea, to help you breathe when you cannot breathe adequately yourself. Intubation might prevent a heart attack or a respiratory arrest. Refusal of intubation does not mean refusal of other techniques of resuscitation. If you do not want mechanical ventilation, you must discuss intubation because it may be included as part of your DNR order. So even if you have completed a DNR order, that does not mean that you have refused to be intubated. So if you do not want life mechanically sustained, you must discuss your decision about intubation with your doctor. So those are the two differences with each order. Does that make sense? Are there any questions? Okay, so now we're moving into PULSE. So PULSE is a physician orders for life-sustaining treatment. What's happening now here in the state of Nevada is they're trying to totally get rid of a DNR form or order and have it all within PULSE, because PULSE in fact does state if you want CPR done or not. So that order's within the PULSE form, but currently now you can have both. But what happens is if there's conflicting statements within your PULSE form and your DNR order, they go by the most recently signed and dated document. So say, for example, your DNR order was last year and you just updated it this year, your PULSE form, they will go with what was stated in your PULSE form. So just being aware of that if you're worried about it too. So the PULSE form commits your doctor to your wishes. Again, as it states, it's a physician order, so the physician has to give this order to you. You can ask the question too, depending on if it is an illness, a terminal illness that you have. Typically, for PULSE should be completed for any patient who has a life expectancy of 5 years or less, and if the patient has a terminal illness. So say, for example, you speak to your physician and that is what the diagnosis was, you then want, and they don't offer you the PULSE form, you want to ask them about filling out that form. So like a DNR order, a pulse tells emergency personnel and other medical providers whether or not to administer CPR in case of an emergency. A pulse is often prepared to ensure that different healthcare facilities and service providers understand a patient's wishes. And we'll go over the form in more detail. It's usually printed in a very a bright colored paper. Here in Nevada, they try to do it in a hot pink form, so that way when you're transferred in the hospital, they see this bright colored sheet of paper and it's easy to see within their medical file. So just to be mindful, it does not replace your other directives. As we will see when we're going through each section, it just kind of states who your healthcare agent is. It doesn't go over all that is stated within your living will or your durable power of attorney form. So we already mentioned this. Your doctor will fill out the form based on the contents of your directive for any patient who has a life expectancy of 5 years or less, if they have a terminal illness. So we'll go over this form in just a second. I was jumping ahead there.
Can we switch to it?
No, in just a second. Let's try. So just like living will or other form of advanced directive, the issues covered in pulse may include the resuscitation, mechanical ventilation, tube feeding, use of antibiotics, requests not to transfer to an emergency room, requests not to be admitted to the hospital, and pain management. So within the pulse form, and you'll see that in just a second, it indicates what advanced directives you have created and who will serve as your healthcare agent. And then like an advanced directive, pulse forms can be canceled or updated. So the difference between a DNR and a pulse form 2, unlike a DNR order, a pulse form includes directions about life-sustaining measures, such as intubation, antibiotic use, just like how we mentioned earlier. The pulse form helps ensure that medical providers will understand your wishes at a glance, but it is not a substitute for a thorough and properly prepared healthcare directive. So you can obtain the pulse form here at nevadapulse.org. And you can order the form. It's usually a $5 fee when you send it back and you get a wallet-sized card stating that you have a pulse form. And this too is updated as well on that Nevada Living Will lockbox. It will show that you have a pulse form as well. Okay. So within the website too, if you go on to the nevadapulse.org, it's a really handy resource too. It has stories about patients and families, you know, some of their personal stories. If you wanted to read on that and get a better understanding, there are resources on there too. When I presented this on Tuesday, I was informed by a colleague that this form will be changing. With the legislative meeting in February, they're going to be changing it hopefully beginning of March or the end of March. So just to be mindful of that, maybe look back onto the website after April to get a more updated form. Only because this Nevada Pulse form is different than other states. Typically, it's like a generic form from all states. So Nevada is the only state that has a different form than that of any other state. So they're going to be making some changes there.
But any that were done prior to that change are still valid, right?
Yes.
Okay.
Yes. So I mean, with the updated Pulse form, if you have an old form, it's still valid. But if you wanted to change it, again, you just get the most updated form, sign, witness, and date it, and we have the physician help you with that because it is the physician's responsibility to help you fill that out. So here we're going to go over them. So on the first page, It discusses the medical order. So consult this form when patient lacks decisional capacity. It is intended to be honored by any healthcare provider who treats the patient in any healthcare setting. A section, and this is important, a section not completed does not invalidate the rest and indicates full treatment for that particular section. So this is self-explanatory: first or last name, first name, middle initial, your date of birth, the last four of your social, and your gender. So side 1, section A, CPR. So this is where that DNR order comes into play with replacing it with pulse. So this is what it looks like here. So you'll see CPR. Patient resident has no pulse and is not breathing. So your two options are: 1, attempt resuscitation. And if you select that, you see section B for full treatment requirements or full treatment required. And then the other option is allow natural death. So do not attempt resuscitation. So here it says if available, the EMS DNR number. So when not in cardiac or cardiopulmonary arrest, follow orders in section B. So then we go to section B with interventions. So these are comfort measures. So this is attempt resuscitation as marked in section A. So this patient is not in cardiopulmonary arrest. If checked, patient should remain at current location, whether that be home, nursing home, etc., unless comfort cannot be achieved at that particular location. And then underneath each section, it usually has other instructions. So if you want further details when discussing it with your physician, that is where you could put it there. So section B, when it comes to medical orders, limited medical interventions. So pulse is only used if patient is so sick they cannot speak for themselves. To discuss the implications, what it may involve, and how it may affect quality of life and life extension. Very similar to an advanced directive, but this is the shorter version of it. So limited medical intervention, comfort measures always provided. So life-sustaining antibiotics, what you decide to do there, and you check that box. Artificially administered fluids and nutrition, and then other limitations of medical interventions. So when it comes to section B, interventions, full treatment, treatment may or may not be successful and may result in additional discomfort. You want to discuss additional instructions, which might include a trial period of treatments to determine tolerance and benefit for that person. So it's all about the quality of life that you want to sustain with that full treatment option. So section C, the last section on page 1, this is required for validity. So it needs the date and signature of the physician on here for it to be a valid document. So on the second page, with organ donation, this section only states and refers to your license to denote if you are an organ donor or not. So typically when you renew your license or have a license or get a license, they'll ask you if you want to be an organ donor, and that's where that will be stated. So just to clarify, checking, section D box does not give authorization for organ donation. It only directs someone to your license or ID for donation status. So section E, the advanced directive summary. So you want to provide your advanced directive to complete this section. If an advanced directive is registered with the Secretary of State livingwilllockbox.com, provide your ID card. So you have that option. So in section F are signatures. The party with whom the decision was made regarding pulse options. Agent is the person specified in the patient's durable power of attorney for healthcare agent. And the patient or the representative must sign and date the first line. So you want to consent with witness, will reduce confusion and conflict when pulse is needed, but it isn't necessary for validity. Preparer may be a physician, nurse, or social worker, or other healthcare professional. I also wanted to mention too, when it comes to notarizing your advance directive, say for example, you are at a hospital, I had referred for them to have it notarized at a hospital, but I was just informed that since they are a medical team there, since the form states that it cannot be a physician or any sort of medical employee, it will not be valid. So just be mindful that if you have it notarized in the hospital, it won't be valid. You want to have it notarized like at a bank, somewhere outside the medical facility. But that's with the advance directive, not with your pulse.
So the POA sign up?
Mm-hmm. Yes, your physician signs this form for it to be valid, and it's on section C.
No.
But your power of attorney does sign it, yes, in section F.
Dolores, we have a question in Las Vegas.
Yes?
What if you bring in an outside notary that does not work within the facility?
Yep, that's valid. As long as they don't work
Okay.
in the medical facility. That's what I was looking for, so. So section G is registry. Send the pulse and advance directive to, again, the livingwilllockbox.com. Requires authorization form and pulse or advance directive to be faxed or mailed to SOS, the Secretary of State office. Annual reminder and wallet card to assure documents are always available. So there's a $5 charge when you send in your pulse form, but you get that wallet size card stating that you do have a pulse form.
But it doesn't have to be submitted.
But it doesn't have to be submitted to get that with the $5. As long as it's signed and dated, it stays with you wherever you go. The physician has signed it. You put it in your medical records. So that's just an option to you to have. So just to reiterate, when it comes to blank sections, because oftentimes people, will leave a section blank. Any completed section is valid unless the pulse is not signed and dated by a physician in section C, and the patient or the patient's representative in section F. So typically medical personnel will look at those two boxes first before pursuing whatever they were doing to make sure that the document is valid and following their wishes. Blank sections are presumed to indicate full treatment. So if it's not checked, they will provide full treatment for you in that section unless it completes with a completed section that you've selected.
We have a question in Las Vegas. I'm sorry, Dolores, for interrupting you.
No worries.
If you travel out of state and you've already signed a post, and you got in an accident, let's say, or whatever, is it gonna be accessible to any medical provider, or would it even be valid?
It would be valid. So the last bullet point here, a valid post of another state or your state shall be honored in Nevada and other states as well. It is a nationwide form that if signed by the physician and signed by yourself or your healthcare agent, it is a valid document that they should follow. So if you have that wallet size card, that's where it's helpful. When you travel, I had a gal who was in one of my classes and she photocopied her post and she folded it up and she kept it in her bag and in her wallet. So she had it while she was traveling. But it's always good to refer to if you have it in the Nevada Living Will lockbox too. So if you get started now, I think this is why we're having this discussion and this training is getting you aware of it and thinking about it and talking about it so you're able and capable of doing it now versus when you're in that sort of crisis mode. And when you travel, letting the person you're traveling with or or for yourself, just keeping a copy in your purse would be helpful too. Does that answer your question?
Thank you.
Yeah, okay.
Yes, thank you.
You're welcome. So these are the references for today's presentation. It, as I mentioned earlier, was obtained from the Mayo Clinic staff, as well as an attorney here in Nevada, and then the Nevada Pulse. So And this is my contact information. I know we're ending a little bit early, but I was leaving this time here for the next 10-15 minutes for those of you who might have any questions regarding the presentation today, or the training.
I have a question.
Yes, I have a question here in Reno.
So on the facility I work for does not allow us to prepare the post, but we have the medical doctor in the facility who can sign the post with the patient. So if no one signs the prepare information, it's still valid, correct? As long as it's signed by the patient and the physician.
Yes, as long as it says, so F, section F needs to be signed, and that's signed by the person, you know,
Right.
the rest of the patient. And then C, section C and F.
Right, so but that's part of F, the prepares information.
Mhm.
If that part is not signed, is it still valid?
It is still valid if the patient signs
As
it.
long as the patient signs.
As long as
Okay.
it's either the patient or the healthcare agent
Okay.
to sign the form, that's considered valid.
Okay,
So that's my understanding of it, but I can clarify for you.
that would be great.
Yes. Notate that. But that was my understanding when I went through the training. As long as their patient signs it or their healthcare agent signs it, it is valid with C, the physician signing.
Okay.
Is there another question?
She just wants you to send her the notes.
Okay. And then for those of you who have logged on through Zoom conferencing, just be aware that I would need your evaluation forms filled. And for those of you who are attending here as well as Las Vegas and Elko, if you don't mind filling out your evaluation form, it's usually on a purple sheet, I would greatly appreciate it.
Dolores, we have another question in Las Vegas.
Okay?
It's me again. If you're working in a facility that doesn't have medical physicians in it all the time, is there any other professional that can complete it with the patient? Or is there an NRS statute that says it has to be done with a doctor? And if there is a statute, I'd like to have that.
Absolutely. That is a good question. I will clarify that and get an answer to you. It was my understanding that it was a physician, but when it comes to certain situations, as you mentioned, where there isn't one readily available, who then can sign on their behalf if they can, and what that statute then denotes or details. And I'll send that information to you once I know the answer. Thank you.
Are there any other questions?
Any other questions? No? All right, well, thank you all so much for attending. Just a friendly reminder again with those who logged in through Zoom, I had sent you all the information that you need for you to receive your certificate of attendance. So if you have any questions, feel free to email me this afternoon. I'll be back in my office. Otherwise, thank you all so much for attending, and I hope you have a good rest of your week. Thank you. Thank you.